I've been getting a lot of questions about the United States Court of Appeals for the Fourth Circuit out of Maryland and Virginia dealing with the case called Bianchi, which is the Maryland assault weapon ban. Let's talk about that real quick when we get back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Also, if you're not following me on Twitter, check me out at Four Boxes Diner. I'm trying to get additional information about the Second Amendment out on there for people on Twitter. All right, folks, so I don't want to be the bearer of bad news here, but I try to be an honest broker and tell you what I think is really going to happen. Because one of the things I try to do with this channel is I try to look down the chessboard and tell you where I think things are going to go, good, bad, and ugly. And I've been getting a lot of questions about the Fourth Circuit Court of Appeals, which is the Court of Appeals that's out of Maryland and Virginia. And they heard in December an oral argument in a case called Bianchi, which was a challenge to the quote-unquote Maryland assault weapon ban. Did not involve magazines, by the way. It was an assault weapon case. And a quote-unquote assault weapon case. Obviously, these are semi-automatic rifles. And there was an argument in December that a lot of people watching this channel probably listened to. I think I listened to it. And it was a three-judge panel of a pretty good panel because two of the judges have done pretty good on Second Amendment issues, applying Heller and look to be willing to apply Bruin properly. Specifically, the three-judge panel in that case was Judge Paul Niemeyer, who was appointed to the bench by George H.W. Bush, Judge Julius Richardson, who was appointed to the bench by Donald Trump, and Judge Stephanie Thacker, who was appointed to the bench by Barack Obama. So in that three-judge panel, they heard our arguments in Bianchi in December. We still haven't seen a decision on that. Not clear when that decision will be coming down. It could be coming down at any point. It takes several months to write this, especially in a case like this where I suspect we're going to get a dissent. My guess is, and here's the good news, is that in this three-judge panel, we're going to get a 2-1 victory for the Second Amendment. That's going to be a proper application of Nyserba versus Bruin, which is really Heller, by the way, to this quote-unquote assault weapon ban. And I think that it will be 2-1 with Judge Niemeyer and Richardson in the majority and Judge Thacker, the Obama appointee, in the dissent, probably writing a very nasty, scathing dissent against the Second Amendment and guns. That's my guess. We'll see what happens. The reason why I say Judge Niemeyer is probably going to be good is because there was a case called Kobe that arose before the Bruin case. This was a 2007 case, Kobe, dealing with the Maryland quote-unquote assault weapon ban back then. And in Kobe, the en banc Fourth Circuit basically said that no, semi-automatic rifles like the AR-15 are not even protected by the Second Amendment because they are like machine guns, they're military weapons, and magazines that hold more than 10 rounds or whatever it is are also not protected arms. They applied a very cramped reading of Heller, clearly inaccurate, clearly totally wrong, and not even close. Nevertheless, they had the votes in the Fourth Circuit Court of Appeals. It's one of these courts where it is basically, I think, 9-5 or 10-5 or 9-6 or something anti-gun judges. And they're very aggressive, by the way, because if you look at the Fourth Circuit, they tend to be very aggressive in en banking things they disagree with, which I will explain to you why that is not unusual with left-wing courts. But let's go back to the Bianchi case real quick. I think there's an excellent chance we win the panel decision, which will be 2-1, which will be hopefully a very good, favorable decision that lays out some good ideas about the Second Amendment. All they really need to do is apply Heller. It's not a heavy lift. And then to point out that these semi-automatic firearms are obviously in common use. It's a no-brainer. That's why the anti-gunners run around going, there are too many AR-15s. Well, because they're in common use. They're ubiquitous, right? And they'd be even more of them if some of the blue states hadn't banned them and discouraged purchases of them. Nevertheless, I think the panel will come out in our favor, and that's great news. But here's where I need to get real with you. And here's where I have to tell you why I think Bianchi is not going to go to the Supreme Court, why I think Bianchi ultimately will be a failure. in the short run over the next couple years. It's because of what's going to happen. The Fourth Circuit Court of Appeals, like I said, is generally a terrible court when it comes to the Second Amendment. Even one of the well-known conservative judges, Judge Harvey Wilkinson, was appointed to the federal bench by Ronald Reagan. He is terrible on Second Amendment issues. So you add that with the typical left-wing anti-gun judges that I think are all over that Fourth Circuit Court of Appeals, and there's no way that a Second Amendment victory is going to occur. Now, I should mention the reason why I think Judge Niemeyer will rule in our favor in terms of the Second Amendment is because he wrote a dissent in that Colby case. So the majority in Colby was terribly written decision, in my view, against the Second Amendment, ignored Heller's precedent and so on. But Judge Niemeyer wrote a very powerful dissent explaining why that was wrong. He's in the panel on Bianchi, so that's good for us, I think. And then Judge Richardson, the Trump appointee, he was in the majority on a panel that found that 18 to 20-year-olds had a right to keep and bear arms and were entitled to have firearms. That case was later mooted, I think, because the plaintiffs turned 21 years of age, so the case got moot. But he did write the decision, or was in the majority, I should say, saying that 18 to 20-year-olds do indeed have Second Amendment rights because they are part of the people, as in the right of the people to keep and bear arms shall not be infringed. So again, good news with the panel. But what's going to happen here, and this is where we have to get a little geeky, and I don't want to be depressing about this. I just want to be matter of fact here. I think what's going to happen is after the panel comes out in favor of the Second Amendment, the Fourth Circuit is going to rapidly do one of two things, neither of which will be good for the Second Amendment, neither of which will be good for us, and neither of us, frankly, will be consistent with the law. I think they're either going to grant immediately en banc review, and then they will rehear the panel decision and come out with a decision that says, no, the AR-15s are not protected under the Second Amendment. That is one possible option for that, an en banc review that will come out against us. I think they will also slow walk that case as long as possible with the hope that the composition of the U.S. Supreme Court changes in some way. Remember, don't lose sight of the fact that a lot of these courts around America, they read the papers too, they understand, and they desire, frankly, in my view, that's my best guess, that a lot of these judges really would like to see the composition of the Supreme Court change. They'd like to see another Biden judge on there to replace a quote-unquote conservative judge, and if that were to occur, that could change potentially Supreme Court jurisprudence, among other things. That is not exactly a shock. That who's on the court does in fact matter. That's why you have these confirmation battles in the United States Senate. So I do think that after we win the panel in Bianchi, the Fourth Circuit Court of Appeals is going to en banc that, meaning they will hear the case and they will ultimately, I think, slow walk that case. They won't rush it. They'll take their time, buying as much time as possible, hoping that there will be change in the Supreme Court before they issue their ruling that will, of course, be against the Second Amendment. There's also one other thing that I think they could conceivably do, which is they could just vacate the panel decision and send it back as an en banc court to the district court to start anew, and that will, of course, take additional years. Again, the whole idea, as I see it, will be to slow walk the quote-unquote assault weapon case in the Fourth Circuit as long as possible, hoping again for the change in the Supreme Court. So to summarize, I just wanted to bring you up to speed because a lot of people ask me about the Bianchi case and why I don't think Bianchi will be the next case to the United States Supreme Court involving the Second Amendment, involving semi-automatic firearm bans, quote-unquote assault weapon bans, or otherwise. It's because even though we may win the panel, it will get en banc, and that will get slow walked, and it just will not. They will not allow that to get the Fourth Circuit Court of Appeals, in my view, will not allow that case to get to the United States Supreme Court in any kind of prompt fashion. They will delay this for years, is my guess, which is why I don't think the Bianchi case is ultimately going to get to the Supreme Court in the near future as the quote-unquote assault weapon precedent case. That's why I think ultimately one of the cases in Illinois is probably best situated for going to the U.S. Supreme Court in a determination as to whether or not semi-automatic firearms like AR-15s, and I should say semi-automatic rifles like AR-15s and AK-47s are protected arms under the Second Amendment. To me, they clearly are based on the test of the Heller in common use test. So to conclude, ultimately, I think that the Heller in common use test is very good for us and is a no-brainer and an easy win for us when it comes to semi-automatic long guns or semi-automatic rifles like AR-15s and AK-47s. The question is, will the judges that are judicial activists, as I see it, try to slow walk those cases so they don't get to the Supreme Court for multiple years? I do want to make one general observation about liberal judges versus conservative judges, and this is extremely important for you to understand. The reason why it's very easy to be a left-wing judge in America is because their vision of the law is much different than conservatives. You see, conservatives like Justice Scalia, Justice Alito, Justice Thomas, and others, they're trying to interpret the law and apply it regardless of the outcome. In contrast, left-wing judges in America, Democratic judges in America as a general matter, truly believe in their heart of hearts and intellectually, they believe that government is a force for good. The progressive agenda of more government, elites telling us what to do, they think that is the role of government, and they view courts, which of course is one arm of government, as a means by which they can advance the ball of progressivism and the role of government in helping lives. So therefore, when the left-wing judges all across America, and as a general matter, but I'm mostly right on this, when they line up to decide these kinds of cases involving AR-15s or Second Amendment cases, they ask themselves, what is the best outcome for America as these intellectual elites? And inevitably, of course, they think guns are bad. That's part of their worldview, so they rule against guns regardless of what the law and history says. In contrast, the conservatives will often, and this is why you will sometimes see, like we saw last week in the Alabama voting rights case dealing with the Voting Rights Act, you saw Justice Kavanaugh and Justice Roberts ruling with the three quote-unquote liberal justices on the Supreme Court to rule in favor of the plaintiffs challenging the Alabama maps as allegedly discriminatory because Roberts and Kavanaugh, rightly or wrongly, were trying to apply the law to get it right. And again, this is why you will sometimes see conservative justices or conservative judges ruled in a way that appears as if they're giving rise to a liberal outcome because they're just trying to apply the law whatever the outcome is. In contrast, the left-wingers like Ruth Bader Ginsburg, you always knew how they're going to vote because they viewed themselves as a super legislature that made sure that if we, the people, or the legislatures in America did not get it right on issues like gay marriage, for example, don't worry about it. The courts, such as the Supreme Court in the gay marriage question, will step in and get it right for the progressive movement. Again, this is why I think the left-wing judges, it's a lot easier to pick them because they're always outcome determinative. In contrast, the conservatives are really process-oriented. For better or for worse, it's certainly a more honest approach to the practice of law and to the application of law as I see it. Nevertheless, the reality is it gives the left in America that are judges, at least, a distinct advantage. At least that's my view, because again, it doesn't matter what the law is. They're focused mostly on the outcome, and that's a lot easier to do than to try to figure out what the law means and do the homework and the hard work that sometimes goes into figuring out what the law is and how it's to be applied. And I think when we're talking about these Second Amendment cases, such as the BIANCHI case, even though it should be an easy case when you apply the law, I cannot imagine I just can't see a situation where the majority of the judges on the Fourth Circuit Court of Appeals will allow anything favorable to guns in the Second Amendment to stand for any period of time. It's just not in their nature, and that's just the harsh reality of it as I see it. Maybe I'll be proven wrong, but I'm usually not. Okay, folks, so hope you learned a little bit something here today. Don't get depressed because we're going to find a way to solve the Maryland assault weapon ban issue in other ways. But nevertheless, don't get depressed. But I got to give you the truth, harsh reality sometimes, so you make good choices. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.